Hey, welcome to the Strategic Success Podcast. I'm your host, Courtney. Thanks for tuning in. All right, you guys, welcome to another episode of the Strategic Success Podcast. I'm your host, Courtney. I'm here with my good friend, Jared Miguez. So Jared is an attorney and a managing partner at Arena Collective. They have a title company, and that's where I do the majority, if not all, of my deals when I can control it. And we've been doing business together for
8 years.
Yeah, 8 years now. I remember back when I was doing deals with, all these different title companies, and I remember when we met, you were like, what will it take to earn your business? And so I really, that was an interesting way to get with you. But then on top of that, I mean, I threw crazy deals at you over the years, and you guys have always said, okay, let's figure it out.
Yeah. I had more time then, so we were like figuring all the little nuances out, and then now we build a process, and now that we have less time, the process allows us to still handle those at a high level. So the creative.
Well, you guys have a larger team now. You guys have grown and expanded over the years, and so one of the big things. So you guys are, I would say, not. I hate the word investor friendly. You guys are an investor focused title company. Huge on that end. You guys know how to handle the creative, the complicated, all of that stuff. And so a little backdrop on Jared. But guys, today we're going to jump into a case study of a subject to gone wrong. And we're going to talk through really at a high level some of the issues. And then I want to really highlight one document that you should never use in your subject to transactions. And it used to be widely taught. I think it still kind of gets taught from time to time. And then we just kind of want to break this down. And so, but before we get started, welcome to the show, Jared.
Thanks, man. I'm excited because I'm usually on your side of it, and I'm excited to be on this side of it.
Yeah, and we've done some collaborative podcast episodes, so some of you guys, listeners, have heard those episodes where we interview other people together. So I'm glad to have you on, and then maybe we'll have you come on and where it's not just a case study.
Sure.
So, but nonetheless, let me give a high level view of this case study of this deal. Yeah. So, and you and I got brought into it when the client's father got involved to try to help problem solve, and then brought you and I in. And then we came together to try to see, hey, can we find a solution?
Yeah,
so
this was a hey, it's past the point of return, but I'm gonna see if Courtney can solve the problem. And
so 30,000 foot view is a young girl. She's early 20s, was building land got donated to her. She was building a home. And during that process, between shifts in the economy, she also lost her job. She got to the point where the construction wasn't going to finish. Something happened with, I think, either the conversion of the loan, various things like that. Got behind payments, whatever. And during that time, so there was financial hardship for her. And so there was a solution proposed where the builder would basically finish out the property, basically buy it subject to the loan, so title transferred, and would basically finish out and sell it. So here we are. That property is been sitting on the market for, I looked at it, it was like, I don't know, I would have to look, I think 150 days on the market in a slower market. Yeah. So it's been finished, so, granted that happened. But then, the dad reached out. He's like, look, my daughter, she made a bad financial situation happen. She made this decision, and now the foreclosure process has started. And we believe that it was actually a due on sale triggered that, and that the lender recognized that the title had transferred.
So did the builder fail to make the payment to see if he could continue to make payments, or did he stop making payments?
So here's the hard part: the builder stopped communicating.
Gotcha.
When things started going south, the builder stopped communicating. So there's some issues there, right? Yeah. And then the daughter is like, look, my credit's shot. That's fine. Like, she's not worried about that. Yeah. What she's worried about is her husband is in law enforcement, and his current job would be okay, but if he would ever want to transfer to another division or something, that foreclosure on his record would be problematic.
And he was not on title, from what I remember, but he did agree to co-sign on the loan. So his debt was connected to that. So there's
his credit is
a
involved.
whole bunch of
Moving parts, right?
Yeah, for sure.
And so, so the dad was like, what are our, my daughter's getting foreclosed on a property she doesn't even own anymore. What are her options? And so one of the first things I said was, please send me everything you have, that from the closing, right? And as soon as they sent that, and he sent it almost immediately once we got off the phone. And as soon as I saw what they signed, I just, the way that I was just exasperated with it, I was just like, man, because ultimately, the goal here isn't to, name names or do anything like that. The goal here is to kind of talk through the case study and say, I wasn't party to it. I don't know what the other parties did or didn't do fully, right? But I think it's good to kind of hear the case study to learn from, because so many people, they only, you can learn from failure, right? It's actually, unfortunately, it's decent.
One of the best tools.
One of the best tools as far as education.
And I'll say this too, because after having a conversation with the father, there are some solutions to this. There's hard solutions that are very expensive. Yes. And I ran through all those with him, and he wasn't willing or able to commit to making those types of solving the problems in those ways. Yeah. And so we can talk about that later on too. But I thought like the creative ways of solving that problem, like there are very reasonable ways to get that done if you're able to kind of wrap your brain around them and you're willing to solve the problems. Like, is the friction that you have from your inability maybe to transfer jobs from the son-in-law standpoint, does that outweigh the cost that it would take to solve that problem? You have to figure out what's more important. Sure.
So yeah, because like right now it's kind of a preventative. They're trying to prevent something that's not really an actual problem today, but would be a problem down the road.
Yeah.
And so, yeah, all the solutions that I ultimately emailed and outlined to him, it was just like, none of them were the easy button. And it almost, when it comes to my desk, it's like rarely an easy button.
Sure.
Unless it's like, well, here's the cash offer and I can make it easy for you, but it's like, you've got to make the hard decision of, do you want to take it?
Yeah. Sure.
But the reality there is, ultimately what, like, I understand that, like, this was a creative offer on the contractor side. Like, hey, I have a client. It's not going according to plan. If anyone is talking about how their deals are all going according to plan right now, they're lying through their teeth or they're not actually out there doing deals.
Sure.
Right? Like, I'm not immune to deals going wrong. I mean, I just, right before the Snowmageddon, I had a tenant canceled their year lease, left the keys on the counter and said, hey, we just moved out, sorry. And I'm like, add that to a vacant property we have to go winterize. I'm like, are you freaking kidding me? Whether it's stuff like that and that was a property that proved hard for us to rent in the first place. So now I'm like, God, that's the last thing I want is to have that property there where we have to get it rented back out again or whatever. Whatever it may look like, right? Deals don't go according to plan. And so there's a lot to be said. Around how people respond when a deal doesn't go according to plan. And I can't fully speak to on this deal, right? Like, I have a limited understanding of it, but can we take some lessons? Can the audience take some lessons from, hey, when a deal goes wrong, what are some things like, right? Obviously the buyer, the contractor had a client, again, financial hardship, some issues. And so they're like, hey, look, I can bring the rest of the money to finish it, and then, like, let me get the upside. Like, let me benefit from it. Well, that makes sense, right? And so then ultimately, they basically then went to a title company to do that transaction. I do not know what was said to the title company. I don't know anything like that, but I did see what was signed that the father sent. And let's kind of, you want to talk through that part? Let's kind of talk through what we saw just from their end they signed. Yeah. We don't know if they signed additional documents and they that wasn't kept in their records that was shared with us.
Yeah. Well, I'll start with this. I mean, when you're going to do a subject to transaction, there are a gigantic set of disclosures and documents that we have prepared that aren't typical for any title company to necessarily have. It's something that we've kind of developed. It's not like rocket science or nothing novel, but just doing so many of these, we kind of know what disclosures need to be in place, what authorities need to be in place, what authorizations need to be in place, so that the buyer and seller have some opportunity to take action if one of the parties don't perform, and be able to function individually without having to necessarily have the other party involved. And there's a whole stack of documents. This scenario, none of those are signed, as far as we know.
As far as we know. And it actually makes sense, because one of the things the father said was, at one point, the wife of the contractor was communicating and was saying that the lender was giving them issues with like payoff numbers, which would make sense if they were not basically involving them to get payoffs and all that stuff. And so when they had a buyer on the hook, right? And so I see subject to deals as one, they have all the creative deals now to my like creative 5.0 and above friends, which by the way, when I did those 9 deals with Pete Fortunato, you guys were involved. Of course, he made it, those are some of the most complicated deals of my career. But apart from like the creative, 10.0 or whatever, apart from those, subject to is easily one of the most complex creative financing deals because of all the moving parts. And so I'm just going to straight up call bullshit on people and gurus saying this should be what people should do on their very first deal. Like newbies should be doing this, right? Because there's so many moving parts. I'm sure you get questions, just like I do, all the time of people who are like, they're like wanting to do a subject to deal because they watched a 60-second TikTok. And they're like, they don't know the first thing to do. Right?
100%. I mean, even some real estate agents who are trying to help investor clients with those types of transactions, it's pretty easy for you to spot somebody who's never done it before, don't really know, because they don't even know how to, what the information is needed in order for them to be able to make an informed decision as to whether it's a good deal or not. And so, part of it's fun to be able to teaching people those things, but you have to be very careful that you don't get in a situation like these people are, where you don't truly know and get the advice on what the consequences are for the whole picture, and making sure
for both parties.
For sure. Because in this scenario, when the payments weren't being made, to get the proper advice to know you got to stay on top of it even after you've sold it. You can't just walk away and turn a blind eye to it and assume everything's happening, because at the end of the day, you're still on the hook as that seller. Your name's still on those loan documents. The buyer has no formal relationship with the lender. It's still on you. So you have to understand that in order for you to protect yourself, you have to pay attention. That's the first thing you have to do.
Well, and to understand it, it's not so simple as, like, let's just say a contractor is listening to this and they're like, hey, if I ever had a client go south, let's just, transfer the title and I just make the payments. It's way beyond that. You've got to, again, you have to have this stack of paperwork that allows you to operate, right, and to navigate it. But you've got to address the insurance. We don't know if that happened, right? You have to do that right, or that could cause you issues. You have to understand the risk, right? And so, like the due on sale clause or various things. But I see people all the time. They either don't change the insurance, or they have, even worse, 2 policies. So they're paying for basically no insurance. And then at the same time, there's all these other moving parts. And so it's not just, oh, well, then let me just send the money to make the payment. There's more to that. And then I can't speak to if this builder knew what they were doing or knew how to communicate it to the young woman, right? And look, plenty of times when people are distressed, they're like, yeah, whatever. Like, how does this get me? Let me just sign whatever gets me. But like, my biggest thing is, guys, you've got to be clear. Brene Brown says it. I love what she says. She says to be clear is to be kind. So then the adverse of that is to be unclear is to be unkind, right? And so that's why I'm like, I lead with education. I'm like, look, give me my 5 to 10 minutes, and let me just explain this.
So let's talk about what happened and what was done in this scenario. I mean, I think that it was honest, just lack of awareness and understanding of the situation. And I think, like you said, buyer thought that this was an easy way to get out of it. They trusted the owner thought it was an easy way to get out of it. They trusted the buyer. But in this scenario, the parties transferred ownership through a quitclaim deed and a quitclaim deed only.
And so let's explain, so when they transferred the title, so in a traditional subject to, the title will go from, the owner to the buyer. So that's really important, right? And so, but doing so, the old school method was to do a quitclaim deed. Can you explain, what a quitclaim deed is? Because it gets talked about in real estate, and it is my least favorite thing that people don't realize. That is a piece of crap.
Yeah. The quitclaim deed is pretty much you stating that I am giving you whatever rights that I have in the property, but I'm not warranting anything related to ownership or any rights that I have in it. I'm just saying that if I have an ownership in this, whatever rights I have, whether that's a fractional portion of ownership or full ownership, I'm giving that to you and I'm walking away from this scenario. But you cannot hold me accountable to any warranties that you would traditionally get that you would get in a traditional full deed.
Well, and here's what's crazy. So you guys own this commercial building. Right now, if I was, conniving enough, I could go get someone to pay me $50,000 to quitclaim my interest in this property to them. And I don't have any interest, but whatever interest I have, I'm quitclaiming to them, even if it's zero.
Yeah, and so, quitclaim deeds are used in a scenario in which you're trying to clean up title, generally speaking. So, like, if somebody acquired tax rights in a property at some point, and the person who owns the property wants to redeem those tax rights back, you would quitclaim those rights and whatever other rights I have back to the owner. And it's used mostly for a curative tool. And in other instances, sometimes the seller doesn't want to feel like they can have they're not want to certify anything, and they're protecting themselves, and if the seller has enough leverage, they can do it. But from the backside of buyer, even if you do have title transferred to you through a quitclaim deed, you can still do a full title search to assure that the seller does have title and all those things. But again,
you can basically go do the long form math basically and figure out the research, right? But when title conveys, people don't often know this, but like Title 101, there's different ways you can convey title. The worst way to convey title is through a quitclaim deed.
From a buyer's standpoint.
From a buyer's standpoint, right? Because you're basically getting, unless you did your research, that paper may or may not be worth anything. Like my reference with this building, right? It would mean a lot if you quitclaimed your interest to me, but it would mean nothing if I quitclaimed my interest to you, right?
Sure. And just to kind of go a step further, like if you warrant title through a cash deed, and you sell the property to somebody and you don't have ownership, they have some leg to stand on to come back and say, hey, you warranted title and you didn't have it. So now I by you warranting it and when you sell me the property, then there's some consequences for that. Now that relationship is just between the two parties. So let's just say you sold me property and warranted title, and I gave you the money that we put on the contract that I was to pay you, and you go spent that. Well, now just my recourse just against you. And like, if you don't have any money, you can't squeeze blood from return it. But if I got a title insurance policy, now you're backing up that and stating that if Courtney can't repay me because she doesn't have title, then the title insurance company will then protect my position. And then to take a step further with that, you can get the same insurance through a quitclaim deed, but the title company that you hire in order to do that closing is going to have to do the due diligence to make sure that it's worthy to be insured. To know that, okay, even though Courtney said I'm only going to quitclaim this property to you, I know now, do my due diligence from the title company and the insurance policy I have, that I will be protected in another way. I don't have recourse against you because you didn't warrant title, but I do have the ability to go make a title insurance claim.
And so if someone ever had a seller that's the only way they want to do it, get title insurance. That's an additional way. Make sure that you're doing title searches and all that you're hiring the right professionals to help with that. So the old school method was for subject to deals was to just quitclaim their interest over, right? Again, shitty way to transfer title. You want a warranty deed, right? And so a general warranty deed is how you want title transfer in general, right?
From a basic standpoint.
On a basic standpoint. And so With the subject to deal, so guys, let me just be very clear. You do not want to use a quit claim for subject to deals. That should be, option Z, and you should try everything else, to not have that. So then the issue there is when I saw that title had been transferred via quitclaim deed, the reason why I immediately got pissed because it doesn't give the seller any protection or recourse.
Mm-hmm.
Let's talk through how we normally do a subject to deal. Is if you want to explain that part.
Yeah.
So we don't use quitclaim deeds.
Yeah, and so and this is kind of a question to you too before we get too far into this. Like when we do a subject to deal, and somebody says subject to, I think the investor world sees that as it's actual transfer of ownership, mirror wrap mortgage type of a situation as opposed to a bond for deed subject to, right? You wouldn't call
a bond for deed subject to is an exception.
Gotcha.
It is not a traditional subject to title transfers.
Gotcha. Okay. Yeah. So and obviously, we always ask for the clarifying point: are you going to transfer? Is it going to be through a bond for deed or an actual sale? Just to make sure that somebody who might, we have the same language going there. But yeah, so when we're going to handle a subject to transaction traditionally where the title is going to transfer, we are going to have a cash deed transferring ownership from the seller to the buyer.
Mm-hmm.
But at the same time, the buyer is going to sign a note mortgage back in favor of that seller that states that I'm obligating myself to pay your mortgage on your behalf. And it's a mirror wrap mortgage. It's going to mirror the seller's mortgage with their current lender. Yeah. And it's going to state that, again, buyer's obligated to make those payments on the seller's behalf.
Right, which is where that promissory note so let's just say you're the seller, I'm the buyer. The promissory note that I give you is reflective of basically the obligations that you have with the lender, but instead I'm making it to you versus to Chase Bank.
Yep, that's right.
So you made it to Chase. I'm mirroring your obligations by making those obligations to you.
Yeah. And so we always talk about this if we ever have a presentation, and I think this kind of brings clarity to people. There's two relationships that are established when the subject to deals are signed. Mm-hmm. The existing relationship, the first one has always been there between the seller and their lender. The seller's always obligated to make those payments, right?
Yeah.
And that
relationship, they signed on the dotted line.
Yeah. That relationship's not going away. Yeah. But the second relationship that's being formed is a relationship between the buyer and the seller that says the buyer is going to pay the seller's mortgage company on the seller's behalf. That is the second relationship that's formed. There is no direct relationship between the buyer and that lender and that mortgage company. It's only between the buyer and the seller. But again, the paperwork is what gives the seller the ability to take action if the buyer doesn't act, which has happened in our scenario we're talking about today.
Right. And it's important, like there's no official relationship with the lender, but there may be paperwork that allows the buyer to navigate things with the bank, but there's no official relationship, and so they're separate. And so the point here is that by doing the mirror wrap, that allows that the mirror wrap mortgage with the seller, it allows them to be in essence a creditor position. So if I didn't make payments, they could then the two ways that if there's default that they could actually get the property back is the first one is if it's really two scenarios. Are we talking and are things, are we cooperative or are we not?
Yeah. And
so if someone's cooperative, if they're, hey, look, I can no longer afford this. There's I had a death in family or this economy, whatever, my things aren't going according to plan. What could the buyer, what if they're cooperative, what's the first way in the form of default can the buyer give title back to the seller?
Yeah. So if the parties are cooperating, easily could the buyer just transfer their interest back to the seller and say, I'm giving the property back in exchange to cancel the note mortgage relationship that we have. That's a very simple thing. And we encourage people to do that. I mean, if the buyer's having a hard time and the seller calls us and says, "Hey, the buyer's in default. What's what can I do?" And my recourse, I always tell them, first of all, let's have a conversation and see if you get title back. And just to take a point of clarification, there are a bunch of reasons that the buyer can be in default, and we specify all those things, right? If they don't have insurance, they don't pay the taxes, if they don't make the monthly payments on time, if they don't, all the different reasons.
Yeah. And
so all of those reasons is why the buyer can be in default.
There could have been a balloon, and they could have missed a balloon.
All those things apply, and so all those are very specifically spelled out. And so, let's kind of take a step back, and before we take another step forward, in this scenario, the quitclaim deed only said title transferred, whatever rights that buyer had transferred. In that scenario, buyer owned it, so full title transferred to the seller. But there were not all of those things that stated in the case that these people don't do all these other things like make the payments on time, pay the insurance, all that stuff.
Yeah.
Then
it didn't obligate anyone for anything.
Yeah. The seller would have had the right to then take the action that they're calling us and asking us, what are my solutions? We would have first said, let's look at this note and mortgage document and say, okay, what teeth do you have to be able to pull this property back?
Hey guys, Courtney Fricky here. We've got Aussie Steve. And look, if you have a deal that needs to get moved, Southeast Louisiana, even in South Mississippi, we're your folks. We are the largest dispo company, really in the greater New Orleans area, even Southeast Louisiana. We have great contacts in South Mississippi as well. Steve, why do we move more deals than others?
Just we're very deep in this market, so Greater New Orleans can be really confusing for national wholesalers. The comps are hard. We change block for block. We got flood zones. We get a lot of hurricanes and the likes, and just a lot of the national platforms don't have the buyers on their list. So we are deep with buyers, but we're deep with relationships, which is really important in this market. So we love JVing with out-of-state investors.
Like I said, we do a ton of business with other investors. So go to homebuyerlouisiana.com/Courtney. Fill out the information, we'll get in touch with you and we'll move this deal along.
Or what the other scenario is, and if the case they're not being cooperative between the two parties, foreclose on the property ultimately.
Well, and that's where the paperwork needs, like when things go wrong, you stand on your paperwork. If you have no paperwork, like I have a neighbor who I've been talking with, she's an elderly woman who lives in a duplex, and her husband's passed away, so she's really dependent on her tenant for income, and she has a verbal lease, and so she's like, my tenant just moved her grown son in, and he's talking about moving his wife in, and she's like, I don't want all, like that's not who I rented it to, right? And I was like, so that's when I learned she didn't have a lease, and I was trying to explain to her, when you don't have a lease, it's really hard. Because basically the boundaries, the obligations, the agreements, all of that are not set in place, right? And so we were talking about the risk level when you don't have paperwork. Then on top of that, you should build your paperwork according to the deal, right? And both parties should be protected, right? And so there's a level there that because the quitclaim does not include any of that stuff, it actually hurts both parties, whether the buyer knew it or not. Because I have had, I had a subject too I bought last year that I did with you guys. One of my wilder ones. Funny to think through that, but it was a divorce. They were facing foreclosure. The wife was on title, but not on the mortgage. And when I tell you, she tried to sabotage every step along the way. I mean, the day we closed, the night before, she called me at 10 o'clock cursing me out. And then the next morning she showed up, smiled, and was, hugging me and thanking me. And I'm like, man, I wanted to say some 5-letter words, but there was a level that we literally, there's paperwork that I was like, look, because her credit was not at risk. She could have called the lender and sabotaged, the transaction. And so we built specific paperwork that talked through like that they're obligated to cooperate, and if they interfere with the transaction, that thereuld be consequences.
Well, and in this scenario,
and so that to protect me as the buyer.
Yeah, and in this scenario, this builder, he is now facing the consequences because the bank is foreclosing on this loan, and if he could lose all the equity he put in this property, the bank is going to go to foreclosure. They're going to collect what they're owed. That's all they're concerned with. If they don't collect another dollar, they're fine with that. And so in this scenario, this builder could potentially walk away losing all the investment he made in this property,
as well as any equity captured.
Exactly. So he has but he doesn't. Again, and we talked on the note mortgage, and I know we're going to talk about some of the other documents, but in this scenario, this builder has no authority to act on behalf of the seller and speak to that mortgage company, which is another huge factor and thing that we make sure of if we're doing these subject to deals, is making sure that because there's two relationships and there's no formal relationship between the buyer and that lender, that buyer has got to have the seller give them some authority to go speak to the mortgage company.
Yeah, I can't call your lender and say, hey, start talking to me about Jared
Mhm.
and his loan.
Mhm.
They're just not gonna allow that, and so there's special paperwork that's needed. I've had to do, the last more major hurricane we had here was Hurricane Ida. I had to do a ton of insurance claims on my subject to deals,
Mhm.
right? And I'm getting checks made out to both, the seller and the lender that I had to navigate.
Mhm.
And if I didn't have basically the subject to packet that gets done at the closing table, where it gives both parties teeth to navigate the deal.
Yeah.
Both sides, when you do not properly do the paperwork, it is really hard to get the money part, working right for you. You put it all at risk.
Mhm.
And so, ultimately, I want to kind of still keep it, 30,000 foot here. Some of the options, I just kind of want to talk through. So because title was conveyed truly in one of the worst ways you can convey it, the seller basically didn't have a ton of recourse in that sense. Like in a traditional subject to, again, we talked about the ways for default.
Mhm.
The paper would have outlined in the event of default, what could the seller have done.
Yeah.
Well, that wasn't the case here. And so then the other part there is they're ultimately not trying to save credit. They're not trying to make money. They're not trying to get the property back. They're just trying to stop the foreclosure because of the fear of the son-in-law, like his the husband's job, right? And so some of the options that we gave were, again, not the easy button. It was go negotiate and buy the property for the as close to the payoff as possible.
Yeah.
And
in that scenario, I suggested them do that. Move your family in there because you get favorable financing terms. Solve their problem so that they can avoid the foreclosure, and ultimately maybe even turn around and flip the property and sell it, and maybe make some money, or just break even, but get yourself out of the situation, which they weren't. That wasn't something that they were interested in.
I said, or buy it and turn it into a rental.
Mm-hmm.
Whatever it may look like, right? Like, and I said, look, there's plenty. I know the money thing is everyone's biggest kind of hurdle with investing.
Yeah.
I'm like, look, there's plenty of lenders I could refer you to that you could talk through, and it's not, let's just say it was 200,000. You don't need the full 200,000 today. It could have just been that you just needed 40.
Yeah.
Could you get away with 40?
Yeah.
Could you qualify for it? What are some options? Thinking through that part, right?
What do you think about this suggestion? And you've done this more than I have, and so I suggested talking to somebody about buying the lender's lien position.
So yes, you can buy notes and you can buy mortgages. It is very rare for them to sell a one-off. Usually lenders like to sell them in what's called a tranche, like a package.
Sure. Yeah.
And so it's rare for them to want to do a one-off.
But let's just assume a bank has their own portfolio product that's in-house. They have attorney's fees they're going to have to pay for if they want to foreclose.
You can always make the offer, and here's the thing is the smaller the bank, the more probable.
Yeah.
But the reality here is that is a little bit more of a savvy investor trick.
Mm-hmm. In that scenario, though, let's just assume that they were able to pull that off. That seller buying the note now would have that lien position against the builder that is not making the payments, could then foreclose, and technically
he could basically, it would cost him buying the note, and then he would still need, in order to get the property, he would then still need to get it away from the builder and back, basically into position he could liquidate it.
Sure.
Is that he would then need to foreclose.
Gotcha.
And to be able to get it. And so there's a level there that, is it an option? Yes. For a civilian, that one's definitely like QRST, something like that, right? Not necessarily ABC, right? So looking through those, and so again, those are not fun. And we don't know how much, title companies are meant to really, you want to explain the role, at least for Louisiana, like what's the role of a title company?
Yeah, and it's interesting because you deal with all the different people and different business models and different systems in which they operate. I have a couple people that come to mind that just operate in different ways. We have a builder who doesn't like to get title insurance, right? And so he's going to buy a lot, build on it, and he doesn't get a policy, and then find out that there's an issue with the right of way that you can't you don't have an insurance policy to cover your the problem you ran into there. So I see different people trying to cut costs and expand their profit margins in different ways. So some people don't get title insurance because they don't want to do that.
Right.
And in this scenario, the party is going and saying like, look, this is a problem. What is the solution? This may have been their third option, just to quit claiming it over, but they can all think they can afford. And so I would say from my standpoint, when somebody comes to me and says, hey, I want to do this, the first thing that I would say is you have to make sure that you get the payoff amount and the reinstatement amount, and you have to at least run a preliminary title search to know what the condition of title is. Because if I do that, now I can look at it from a title company standpoint and say, look, like, you just want title transferred over to the property. Let's figure out what's owed from the what obligation are you taking from the buyer standpoint? What issues may you run into? What are you actually going to be acquiring full ownership, because this is a fractional ownership with the person who's trying to sell it to you? And so I would say that from a basic standpoint, invest in the due diligence and research on the front end so that you know what you're getting yourself into. Again, in this scenario, I'm not sure what all the details that were given, but I would ask those questions. I had a client call me yesterday while I was walking the neighborhood, and he said, hey, my client wants to buy a property from down the street. There may be a mortgage on it. What do I need to do? First thing I always say is get a borrower's authorization form signed so that you have the ability to reach out to the mortgage company and start getting payoffs and reinstatements, because you don't know what you're going to pay for it until you know what the debts are. And then did a little bit of due diligence, found out that there was a foreclosure already filed, so okay, now we got to go to the attorney, not the mortgage company, make sure we get the attorney's fee included in that price. So, I would say from a basic standpoint, having the knowledge that I do and that John does and that we have and the systems that we have, I'm going to give you advice on where do you start with due diligence to make sure this is a good deal for you and know what we need to do next to make sure that everybody's protected.
So this is a whole nother video for another day, but when it comes to it, most people don't realize one of my biggest issues is that so many people, when it comes to a subject to deal, they treat it like another deal, like just like a cash deal or like a DSCR purchase or whatever. But the reality is there's so much additional due diligence that comes in with a subject to that people just overlook. And a huge part of that due diligence also has to come with both parties understanding the risk and the benefits, right? They do the deal because of the benefits, but they need to understand the risk. If, I had a broker forward me an email where an investor had made an offer on a listed property for a subject to, and they literally said that once this happens, there will be absolutely no risk to the seller. They can just completely move on, no issues. And I was just like, and you put it in writing? Like, you first of all, like, that's your, tell me you don't know what you're doing without telling me you don't know what you're doing, right? Yeah. So there's there's absolute risk for both parties on both sides that you should understand. That's one of the reasons. There was a period in time when I was getting like 10 phone calls a week saying, Courtney, what the heck is subject to? I'm getting all these offers on my listings, right? Yeah. That I created a class that you and I have collaborated on numerous times called What the Heck is Subject To? I teach at brokerages, and usually it's a creative financing 101 where just a portion of it talks about subject to. Well, pulled that out and then made the whole class about subject to because they've become so prevalent. But the issue here is because it's popular, you then have all these speculators who are just speculating that this is how they're going to get rich quick. Yeah. But then they don't know what they're doing, and they're getting into these deals. Have no idea if that's the case here with this builder. Some of the paperwork alludes to it, but the reality here is that, if someone wants to be effective, if they want to do a good subject to deal, if they want to do good business, and if they want it to be successful for them, and really it has to be successful for all parties for it to be successful for them, especially in a subject to, because it's really a dance more than anything. That seller is staying in this transaction with you for the life that their name is on that loan. Sure. Right? And so it's so important. They've got to get these things right. You've got to understand there's additional due diligence with the subject to deal, all of that. So as we start to wrap up here, what are, obviously, so pitting this case study kind of behind us, just saying, when subject to deals don't go according to plan, this is probably my third or fourth case study of subject to deals gone wrong, because I want investors to understand what have been these points of failures. Yeah. And it is very often in the paperwork.
Mhm.
And so that is why it's so important to work with the title company that knows what they're doing. I cannot tell you how many attorneys have called me from other title companies, and when they're talking like, the thing that's an assumption, and then I realize they're talking about subject to, and I'm just like, oh.
Yeah.
If they think they're the same thing.
Yeah, and tell me you don't know what you're doing, without telling me you know what you're doing.
Well, yeah, and so there's a level there, then it makes me very worried for their paperwork, right? And so my last question for you is this. On the attorney side, you guys have continued education, right?
Sure.
On the attorney side, has there been any education for you on stuff like this?
No way. It is. I mean,
Was there a paragraph in law school?
No,
You know what
I mean, you talk about. I mean, you talk about it. The actual HUD document has a line on there for allowing subject to. Like, it's a thing, and people understand how to work the system, and it's basic contract. And at the end of the day, and you learn a little bit about this in your obligations classes in law school. So, like, there are like third party obligations and things like that apply, and so a lawyer who actually does a few of these can kind of get their footing. But you have to go to somebody who actually does complex real estate transactions. And there's two things. You said that the biggest thing is the paperwork. The other thing is the due diligence, which we talked about. Yeah. And you don't know what you don't know. And we've had learning opportunities, right? Like, we've had a situation where we had to actually go and we made a mistake, right? And we fixed it. But
you learned it.
Yeah.
Well,
I would ask a question I didn't know the answer to, or I thought I knew the answer to. I asked the people, and I didn't ask necessarily the right question, and I didn't get the answer we needed.
Due diligence is often, when people get burned because of due diligence, it's usually not that they didn't do due diligence, they didn't do enough, right? Yeah. And that's common with investors too, right? And so there's a level here. So you guys aren't like in your continued education, you don't have where you guys, they're saying, hey, here's a class on subject twos and here's the paperwork y'all should be using.
No, but I'll say this. You mentioned that some attorneys don't understand it. We're not greedy. We don't need to do it. We're not like the type of people that are not willing to educate our competitors, for lack of a better way of saying it. We have great relationships with other title companies around here that we'll pick up the phone and have conversations. And so if there is somebody out there who prefers to work with a title company that don't know how to do subject to, we're more than happy to have a conversation with people. We want people to do good business. Yeah. And so I just wanted to make that clear. If there's somebody who watches this because they're interested and they are a title company or work with a title company, like, please have them reach out to us.
Yeah.
I mean, I'm more than happy to explain. I mean, the reality is that the subject to is always going to be there, but it's not going to be as prevalent as it is now when the market shifts. Something else is going to come up.
It's been around forever. It's currently a fad. Eventually, it'll dim out.
Yeah. And so, but the point of saying that is that we all work in the same market, and when somebody gets better, we all get better, and I'm more than happy to give some information. Because, look, it's all about basic business and operating systems and creating a process within your business. And so unless you do it a few times and do some testing and having some wins and make some mistakes, you don't really know. And we've kind of gone through that process.
Well, the repetition helps.
Yeah. We have a system that allows us to be able to solve those problems. And so, if you are an investor who wants to get into this, like you said, you can't just watch a couple videos and learn about it. You need to create a process and build it into your operating system in order to do that. And this is a tool in your tool belt, but it is, like you said, it's not usually A, B, or C.
It's the most complicated.
It's
easily one of the most complicated that I do. And I do a lot of different types of complicated deals. This is easily one of the most, if not the most complicated that I do.
And like you said, we're talking about the paperwork side. We haven't talked about the due diligence that we recommend. We haven't talked about having to deal with insurance. We haven't had to talk about dealing with things after closing. So, there's layers to this that we didn't even get into. Today is, don't do a quick claim deed.
Yeah.
Make sure that you have the proper paperwork on a subject to deal. Make sure you do the basic due diligence, but there's a lot of other layers to that.
Yeah, and it gets really hard because on the education side, I am ramping up content to really try to help, because literally my phone rings off the hook. I have easily worked more than 24 failed subject to deals in our region, and it's like one of those things where it's usually some fundamental failure. It's the paperwork, the due diligence, the numbers. They didn't, they bought a bad deal, but they didn't know what made a bad deal, right? Or they didn't know the process and therefore didn't work the process. Yeah. And so we had all that. It was actually one of the reasons why I created my Safe Subject to workshop. Literally, I called it, I did the first one in August last year, and it is I called it a emergency masterclass, because I was getting so many calls of people who were wanting to get into subject to deals, and they're like, they call me like, hey, I'm under contract to buy a subject to deal. Basically, what's the quick and the short? I'm like, there is no quick and short. I'm like, well, it's like one of those things where I'm like, there's so much I have to tell you, right? Especially when they're like, yeah, I saw a 60-second video on TikTok or maybe a 35-minute video on YouTube, but like, the concept there is that they're like, what all steps do I need to cover? I'm like, dude, we don't, like, I'm gonna try to help you, but like, I don't have enough time. And so that workshop is what gives me the time. It's, 8+ hours and I think I had a 146-page manual for a 1-day class, it was like, and literally I was focusing from once the seller says yes to after closing. What is the process, due diligence, and the paperwork, and the, really the numbers part. So like, how do you know if something's a good deal or not? Literally came out of what felt like over 100+ conversations that every single one of them, I was like, I don't have enough, like, I just did not have enough time to break it all down.
But you had about 40 people in the room.
40 people.
And you had several realtors that in this market that want to understand it better. And you can tell who is learning based and who's growing their business and who wants to add things and knowledge so that they can help the community more.
Well, yeah, because you guys came, because I had you guys on a panel, and then I had my insurance folks on a panel to talk through, that. And because it's, again, I'm trying, I want people, it pains me when someone says, oh, I already did it, and then we go through and we realize they did it wrong. There was some part of it that they didn't take the time to learn about up front or whatever. So with that being said, like, I haven't finalized the details, but I'll be doing that class at least twice this year.
Cool.
March, so coming up soon, March 2025 here in New Orleans, and then actually in Tampa in May of 2025.
Oh, very cool.
And so because it's so many people are doing it right now, but then I'm seeing so many people jump into this transaction and they just don't know. Yeah. And so with that being said, y'all stay tuned, more details coming about that, because that's one of those things where it pains my heart to see when a subject to deal goes wrong. And you and I do business for a reason, because we're very aligned in the sense of like, we want to help whether we're a part of the transaction or not. Because, my shirt, it's how you do real estate matters, but I care about solving the real estate problems in my community. And part of that is helping prevent problems from happening, right? Mm-hmm. And so, any final thoughts here? You get a lot of phone calls about subject to, I bet.
The biggest thing I would say is that if you are a realtor and you get a subject to deal, an offer on a listing, make sure that you call an attorney who knows what they're doing first, or call a local investor to have them vet that deal to make sure that the buyer's credible and that it's a good deal. Because if you don't understand it, if you don't understand the deal, that's okay. There are people here there are people around that are knowledgeable, and there are investors like you that are not interested in buying every transaction, but helping the community do these the right way. And so I know you've said in the past that have people call me, I'll look at the deal. If it's something I would buy and the contract makes sense, then maybe a local investor. Because I tell this to every listing agent who gets one of these offers. Somebody is going to agree to pay your seller's mortgage that's going to have your seller's credit on the line for a certain amount of time, maybe even for the duration of that mortgage. Could be years, decades. I say, I would rather be able to look the person who's going to make those payments in the eye and say, I trust that you seem as though you're a credible person. And so,
and then when they're local, and so when they're local, you can do a lot more. It's easier to vet them out, right?
Exactly.
And I tell agents all the time when they call me, I said, look, the success of the deal, there's things that matter on the seller's side, like for the seller to help the deal succeed. But then, look, the buyer you pick depends on the success. If they don't understand what they're doing, that can cause issues as well, right? And so there needs to be that's just as important as the buyer that you pick on a cash transaction and stuff like that. Like, as long as they perform in that short time window, which Lord knows they don't all perform, right? Like, it's the same thing. It's like when it's the type of financing. There's different things. Like, just because someone's making an offer doesn't mean it's going to cross the finish line. Well, just because someone can buy a property subject to doesn't mean that they know how to do it correctly. Right. And so that definitely matters. Man, I actually was just getting booked today for some more brokerages to do subject to trainings in the area, because brokers are just like, hey, we're getting these offers. We want to understand and basically advise our clients but most traditional agents aren't familiar with this.
Yeah, and brokers are going to liable for their agents making bad decisions, and so I mean it makes a lot of sense for the brokers to invest in
Exactly.
you coming and teaching them how to actually vet the deal, and really more than anything, just giving them the warning signs to look for and the process of bringing on the right people to sport.
Exactly. Look, man, guys, let's just kind of wrap this up. Education matters. That's huge, right? Someone says you think education is expensive, try ignorance, right? It's expensive to not know, right? But then the other part of that is the team you work with is important. And so I tell investors this all the time. Don't just go to your favorite title company and assume they're familiar with subject to deals. I always ask, hey, how frequently do you do them? If they're like, yeah, I do one a year, I would be more nervous, right? If you're like, hey, we do them one a week, or, whatever, one a month, that's a little bit more repetition than, there's a level there that you want to make. Same thing with your insurance company, same thing with whoever's working with you in the transaction. And so you guys have, been great working with you guys over the years. So guys, Arena Collective, Jared, how would folks get in touch with you if they either have, whether it's something like a wholesale deal, a seller finance deal, a BRRRR deal, or a subject to deal?
Yeah, I mean, if you just go to our website, all my information's there, and a lot of, as you're saying this, I'm thinking, like, when somebody initially works with us, I can kind of help them get comfortable with our team, understand how we work, because we have an order opener and then an attorney that kind of manages the file. And so I always encourage people to reach out to me first. I can tell you what our process is. So my email address is jared@arenacollective.com.
I'll put it in the show notes.
Yeah, and then obviously you can text me because I give my phone number out. I didn't put it in the show notes so anybody can have it. But Courtney can get you my information. But also just reach out to us at orders@arenacollective.com if you want to just reach out to us directly that way. But I always encourage people, include me on the initial conversation. I'll kind of get you acclimated with the team. We can go from there.
And you guys can find them. I'll put your socials on here. You guys are very active on social media. You guys have a podcast that you do a lot of episodes. Some of them we've collaborated on, but you do plenty of them beyond that. You want to share a little bit about that?
Yeah, the Indie Arena podcast is a podcast that supports local St. Tammany businesses, the greater New Orleans area, because that's where we're located. Courtney and I, we collaborate on the residential real estate side. And then we also have guests around community, which is nonprofits and government officials in the area. We have military business owners because we support our military veterans who have businesses, and so we want to promote them. We do just general business, the high-level businesses. People don't realize there's such valuable, very successful businesses in our area. We want to bring light to that. And then the last thing that we bring on are media people that are helping market companies and do a lot of social or print ads or personal brands that are helping people grow their businesses. And so we kind of, again, our whole MO is how do we help businesses grow? Yeah. And so we do that through our legal services, through our real estate services, but also through our podcast platform, helping our clients talk about their brand and get their name out there.
You guys are very educational. That's huge. And so awesome. Well, guys, I'm going to put that information in the show notes. And as always, if you want to connect with me, just go to CourtneyFricky.com. Appreciate you guys tuning in today. Jared, it was another good one. Appreciate it.
Thank you.